Hi, my name is Bill Kimmer. I am the managing member of Metro Mortgage Consulting. We are a third-party loss mitigator. We work with people in negotiating short sales on their behalf. We are doing a series of videos. This is a 9-part series. This is section number 5, in which we're going to talk about deficiencies. This is my client, Nina Buckley, and we're going to be talking about deficiencies today, and specifically we're going to be talking about junior lien holders. That would be seconds, thirds, etc. So Nina, earlier in the day we talked about going through and doing short sales. We talked about the fact that there could be deficiency balances, and you had some questions regarding that.
Lots of questions. So I have a second. I took out an equity line of $40,000 with a different lender.
Okay.
So how is that addressed in the short sale process? And then is that the terminology deficiency? I'm a little confused. Can you explain that to me a little bit? Okay.
So basically what's going to occur is when we go through a short sale, the first lender is going to determine how much of the money they're going to pay to the second lender. So in your situation, we have a $40,000 second. In all likelihood, the first is going to allow $3,000 to go to them. They're going to be giving them the $3,000, and they're going to be asking for a lien release, which means they are simply releasing their lien interest in your real property.
In the property, but does that include me personally?
It does not.
Okay.
And this is a very, very misunderstood topic. Because the bank is agreeing to release their lien interest doesn't mean they're agreeing to release the underlying debt. So when you took out your, I think you said you had a home equity line of credit.
Right.
When you took that out, that is an open line of credit, and you secured it with your real estate being your home.
Right.
You are now selling that home, and you are asking the bank to release their lien interest, which they will do, typically, because their only option is to either release their lien interest or to be foreclosed out in a foreclosure procedures where they will get no money. In either event, either the foreclosure or the short sale, the remaining note stays active. So you owe that obligation. But the property that was securing it is no longer there. So that is the collateral on the note. So for all intents and purposes, what you've done is you've moved from a collateralized note to a decollateralized note. And they're going to be looking to collect that note. Now, this is something that's not very well understood. A lot of people think just because they took the money, they've agreed to let you off the hook. And that's not the case. The best time to address this is now. And so what we like to do is try to address that deficiency and work out some kind of either a payment plan, a structured settlement, or a deficiency release at the time of the transaction. Depending on the banks, any of those may occur, but you will be involved in the loop the entire way. It's important to address this now because what you don't want to have happen is for that note to be end up being sold to a collection agency or moved into some kind of collection activity. In Oregon, you have 7 years in which to file a suit against you. And that is 7 years from the last time you affirmed the debt. An affirmation of debt can take various different ways, but typically the cleanest, easiest way to have an affirmation of debt is for you to make a payment. So if 5 years from now you made a payment on a note, the bank has another 7 years in which they can decide to file a suit against you.
So it tacks on 7 additional years each time I make a payment?
Anytime you've affirmed the debt, the creditor has 7 years in which to file a lawsuit against you. So what happens is the creditor has 7 years in which they can file a lawsuit against you. They will clearly win that suit because you owe the money.
Okay.
And they will get what's referred to as a judgment. That'll be a money judgment, and they will have 10 years in Oregon to collect that judgment. They can put it against real property that you have. They can attach your checking account. They can garnish your wages. There's a number of things that they can do in doing this. Now, I own a collection agency, and I ran a collection, the credit department for a large company for years. So everything I'm telling you about are things that we have done as collection tools, and I know you can do it. After the 10 years go by, for $25, I can renew that judgment for another 10 years. So that means I can have a judgment against you for 20 years plus the 7 years that I was trying to collect. So there's a long period of time that you can be on the hook for making this payment. After the 7 years, it doesn't mean the debt goes away. It simply means they've lost their ability to file a lawsuit against you. There have been numerous articles, and I've seen it where unscrupulous collection agencies have bought these notes for pennies on the dollar, and even after they've gone past the statute of limitation, they have filed lawsuits. They've been awarded money judgments, and they've gone ahead and moved on collections. Typically, people do not know that there is a statute of limitation on it, so they don't challenge it in court. Any way you look at it, a deficiency on a subordinate lien holder that isn't addressed is a potential landmine for you down the road, and it's something we need to address now.
Okay, this is scaring me half to death. So is there, how likely is that to happen, or do you think we might be able to?
We were very successful at negotiating this. The banks want to get paid. They'd rather get paid now than later. We are very successful at doing structured settlements, money settlements. I expect that, particularly with the banks that we're working with, we are going to be successful at getting that done. Either way, when we're done, you're going to know where you stand. And it's not going to be a situation where you're having to worry about what's going to happen down the road. If it is a bank, and there are a couple of them, that do not allow you to negotiate at that time, if you are contacted by a collection agency down the road, I'm still here for you. Okay. There will be no additional fees charged. I will negotiate that out for you. I had one about 3 months ago where it took a year for them to be contacted. They did get the contact. It was a $65,000 second. The collection agency was asking for $6,000, and we settled for $3,000 on an interest-free note over a 3-year period.
Wow.
So these can be very, very successful if they're negotiated correctly.
Okay.
Of course, I can't guarantee anything, and you never know what's going to happen. But you're going to have a very good idea where you stand before you sign and sell the home. So
you'll let me know straight out what's going on with the first, what's going on with the second, what you've negotiated before we go to closing.
Right, and I also, and you have to be comfortable with it. You do not have to close if you don't like it.
Okay. All right. That sounds good. Thank you.
You're welcome.